further hearing in the appeal, KD Sri Lanka and the Secretary of State for the Home Department.
Yes, Mr. Chair.
My ladies, my lords, one piece of administration, if I may, to start with. I'm extremely grateful to Ms. Harrison's instructing solicitors for collating and putting into files all of the skeleton arguments that were before the Court of Appeal, which you now have in white folders, I hope, on each of your benches. It may be that it's necessary for those to be uploaded onto the memory sticks in due course, and we'll take the appropriate steps to do that. And may I apologise for the fact they weren't included originally. My ladies, my lords, you'll recall that I submitted yesterday that the upper tribunal had directed itself correctly as to the law, and that this was an important starting point for the analysis of its decision, as it brings this case squarely within the line of high authority to the effect that the appellate court should exercise restraint when reviewing evidential assessments made by a specialist tribunal in this area in particular. And I would refer the court, if I may please, to paragraphs 18 to 25 of our written case in that regard, which are at MS 843 to 846. It was also my submission at the conclusion of yesterday's hearing that the ultimate decision or analysis the upper tribunal reached, having directed itself correctly to the law, namely that the appellant had not discharged his burden of establishing a real possibility that he had been tortured in the manner he claimed, and that SIBP was the only real possibility that remained, a conclusion it didn't shy away from, was the product of a detailed analysis of the evidence, and not an uncritical or default adoption of the SIBP possibility. In particular, the upper tribunal had regard to the background evidence relating to SIBP. It noted, as the court heard yesterday, the paucity of evidence for that practice in the tribunal's case law, paragraph 11. It noted that there was some support for the practice in the academic literature, paragraphs 241 and 248, and it carefully considered the expert evidence of Dr. Arnold and others as to its plausibility and prevalence as a matter of principle. And then, most importantly, in my submission, it explained why, in the particular circumstances of this case, it concluded that the appellant's account was not a real possibility and SIBP was. And in a nutshell, that analysis was he must have been unconscious when the burns on the back were inflicted, and we do not consider it plausible that he could have remained unconscious during that process. In short, therefore, and to conclude the submissions that I was making yesterday, this is a carefully reasoned conclusion by a specialist tribunal that had properly directed itself as to the law. It is also important to note in this regard, in my submission, that the appellant's appeal has never been presented as a perversity challenge, either before the Court of Appeal or before this court. Now that, of course, is, or would be, a straightforward submission for Mr. Drabble to make. It would simply require him to say that on the evidence before the tribunal, the only conclusion it could have reached was that the appellant had been detained and tortured by the Sri Lankan authorities in the way he claimed. What he does instead is to identify a number of specific respects in which he says that the upper tribunal did not adequately deal with certain aspects of the medical evidence. And I'll turn, if I may, to those specific criticisms now. But before getting into the detail of the evidence and turning to the transcripts, which I will, could I make three very short submissions of general application by way of context? The first is that although the original grounds of appeal included a series of challenges to conclusions of the upper tribunal as to the general credibility of the appellant, including the circumstances in which he came to be detained, how he managed to escape, and the apparent lack of interest in him and his family both prior to and after the alleged detention, those grounds are no longer pursued. When you look at the skeleton arguments that have now been belatedly provided, you will see what Lord Justice Sales meant at paragraph 70 of his judgment, when he, at MS 913, when he says that in large part, the grounds of appeal were effectively abandoned at the hearing in the Court of Appeal. The grounds of appeal that were effectively abandoned were those grounds which took issue with other aspects of the tribunal's credibility assessment other than the medical evidence. And that is why you will see, and I suppose I'll get this apology in at this stage, that the skeleton arguments that you've now been provided with shoot at very different targets to the targets that have now been identified for the purposes of this appeal. Now, that's not merely a forensic point in my submission. It's important to keep in mind when we deal specifically with the medical evidence, as of course we now must, given the way the appeal has been framed, that the upper tribunal considered that the appellant's account lacked credibility in a whole range of important respects, and that, per Mbanga and SA Somalia, with which the court is well familiar, the medical evidence has to form part of the overall assessment. The way this case has distilled down means that we're looking at medical evidence in isolation and indeed focusing very narrowly on certain aspects of it. But it only formed part of the evidential picture. And in numerous other respects, the tribunal found this appellant to be lacking in credibility. And if I could simply refer, without turning up, the court to paragraph 36 of our written case at MS 850, we list the 9 most important respects in which the upper tribunal found that the appellant's account was not credible. I should also note, in passing, that the first-tier tribunal who heard him give evidence found that he was wholly lacking in credibility and that he had entirely concocted his story following a number of failed attempts to secure entry to the UK as a student. See paragraph 37 of our written case. So that's the first short general submission before turning to the specifics of the medical evidence. The second general submission is that in acceding to the appellant's invitation to engage in a detailed unpicking of the tribunal's reasoning for the purpose of seeing whether it is possible to identify some inadequacy within it, risks setting a standard for the provision of reasons in asylum cases that would be all but impossible for tribunals to meet. If this case, I submit, does not meet the standard of adequately clear, cogent, and detailed reasoning, it is difficult to imagine a case that would. I respectfully refer the court back to the MA case that we were looking at yesterday and Lord Dyson's observations at paragraph 46 regarding the possibility of finding ambiguity or aspects of reasoning that might be better expressed in virtually any determination. And the importance in those circumstances of not second-guessing, attempting to second-guess, what the tribunal had in mind when expressing its conclusions. Now, that is important in the immigration context for the reasons identified in MA Somalia, AH Sudan, et al. But these are principles that have been repeatedly identified by this court in a whole range of contexts. And we've referred in our written case to the well-known dicta of Lord Hoffman in Piglovska and Piglovska, which of course is a family case. in which he cautioned against subjecting reasons to a narrow textual analysis. And we've referred as well to the well-known case of English and Emery about how it's not necessary to record each and every factor that tells in the decision-maker's reasoning, provided that the parties have an adequate understanding of why they've won and they've lost. And those are at paragraphs 26 and 27 of our case. Now, there is precious little, if any, significant dispute of any of those important observations of general principle in my learned friend's case, and these were not authorities he dealt with in his submissions yesterday. And indeed, it is telling in my respectful submission that the principal authority relied upon by the appellant for the principles to be applied to the adequacy of reasoning by a fact-finding tribunal is the case of Flannery, which is referred to no fewer, I think, than 4 times in Mr. Drabble's case, which, as the court will have seen, and we quote the relevant parts in our written case, was an 8-day surveyor's negligence case in which the judge did no more at the end of the evidence than say, I prefer the defendant's expert to the claimant's. And that was it. And the expressions of principle as to the adequacy of reasons that were made in that case, which he adopts, flowed from that wholly inadequate analysis. And that is, respectfully submit, 1,000,000 miles away from where we are in this case. Now, these are all submissions which could be made, and frequently are, in defense of tribunal determinations, which might fairly be described as somewhat thin. And those of us that represent the Secretary of State in appeals of this sort are often having to make do with tribunal determinations which perhaps could have been fuller or more detailed in their reasoning or more comprehensive in their analysis. But that is not this determination. This was an exceptionally detailed analysis by the tribunal. And not just the tribunal, but 3 very senior members of it. And the authorities speak quite rightly in my submission of the care that must be taken over asylum appeals in view of the seriousness of what is at stake. But this appellant can hardly claim that his case was given anything other than the most careful scrutiny. Thirdly and finally, before turning to the transcripts and the medical reports themselves, could I make the general submission that any assessment of the reasoning that we're about to look at in this case has to take account of the particular challenges faced by the upper tribunal in this case in picking its way through the extensive body of evidence with which it was presented. Now, the extent of those challenges is summarized at paragraph 41 of our written case at MS 852, which the court will have seen. The essential point is this. This was very far from a conventional case in which the court is presented with 2 neatly packaged expert analyses presented by opposing parties from experts in the same discipline from which they get to choose. Usually, of course, these days, with the benefit of a joint statement of agreed issues and disagreements, and careful testing and cross-examination. Here, there were no fewer than 7 experts, including the GP, all called or instructed by the appellant's representatives, from a whole range of different disciplines, some speaking to the same issues, some speaking to different issues, some who'd examined the appellant, some who hadn't, some talking about the same points, i.e. scars, from perspectives of a psychiatrist or a plastic surgeon or a wound healing expert, some who gave evidence in person or in writing or over a bad phone line from Santiago, some who gave evidence solely by reference to reports written some years before. And it is readily apparent from the determination and confirmed by the transcripts to which we'll shortly turn that the upper tribunal received very little help in analysing this evidence from the parties and did most of the work itself in respect of both questioning and analysis. Little, if anything, was said about the evidence in submissions, no particular points highlighted or challenged. There were more detailed submissions from the interveners, but they advanced a series of, as we'll turn to in a moment, inconsistent submissions as to the general approach to SIBP, but didn't provide any help with the specifics of the evidence either. Now, you were taken by Mr. Drabble yesterday to the submissions made by the Secretary of State, Mr. Duffy, the presenting officer. Could I just invite you briefly to turn up the tribunal's determination for the purposes of seeing the submissions that were made by the appellant? And it's at MS 938, please, which is no, I'm extremely sorry. My lords, my ladies, it's not 938 at all. It's 986. Forgive me. Now, at 986, just before paragraph 194, you'll see the subheading submissions, and the tribunal dealt with written submissions and oral submissions separately. Now, the appellant was represented by two counsel, Miss Bayati and Mr. Paramorthy, and their written submissions are summarised at 195 to 197. And essentially you will see that 3 points were made. Firstly, that the medical evidence produced in support of the appellant's claim was capable of amounting to independent corroborative evidence that he had been tortured. I think anybody would disagree with that. Secondly, in relation at 196, in relation to the evidence the appellant gave of being tortured, his account was that he was beaten almost every day, and every 2 to 3 days was inconsistent with that which he gave to Dr. O'Deely and Dr. Zapata Bravo. Entirely sure I followed that submission, but it is there for what it's worth. And then it was submitted at 197 that he had given a detailed account of being burnt in detention and some observations about the background evidence. And then, as far as their oral submissions are concerned, paragraph 219, the only reference to their oral submissions, it is said that, like Ms. Bayati, Mr. Paramorthy, on behalf of the appellant, associated himself with the submissions made by counsel for the HBF, which are recorded in the preceding paragraphs. Now, there is no hint in the record of submissions made to the tribunal of any of the analysis that is now being run. In particular, no hint of any reference to the difference in the appearance in the scars on the arm and on the back. That doesn't get a mention. No hint of any reference to unconsciousness being explained by poor physical condition, illness, dehydration, malnutrition, and so on. No suggestion at all that Dr. Zapata Bravo's estimate of 10 minutes should be regarded as in any way unreliable or speculative.
You said it was speculative.
Well, my lord, I'm going to come on to the I'm going to come on to the transcript in a minute.
Your use of
but
that
he did.
adjective.
Well, it's certainly a word he uses in his evidence.
Right. Yes, well.
And I will come on to it. But the point that I'm making, my lord, for these purposes, and in my submission validly, is that it formed no part of the appellant's case before the tribunal that they should not adopt Dr. Zapata Bravo's estimate of the amount of time that was taken. And we see later in their determination that they do adopt it. And my submission is they were entitled to do so, and one of the reasons I say they were entitled to do so is that nobody, including the appellant, was suggesting that it was in any way unreliable or incapable of being adopted. Of course, I accept what Dr. Zapata-Bravo said about it, but my submission at the moment is limited to the point that no one sought to tell them that he was wrong. And also, just to finish this point, no hint of any submission of the type made by Mr. Drabble yesterday that the evidence of Dr. Alam was not capable of providing at least some insight into the medical plausibility of remaining unconscious during a period of repeated burning for whatever period it may have been. I say that the 10 minutes was open to them as being plausible. But the essential point is that in addition to the plethora of evidence from a whole range of specialisms coming at this case from a whole range of different angles, and you will have seen that some of the experts were instructed to give a general opinion on either SIBP or appearance of scars as a matter of principle, Dr. Arnold, for example. Some were asked to look at this particular appellant and give an opinion, Dr. Zapata-Bravo, Dr. Adili. In addition to all of those difficulties, the tribunal had very little assistance from the parties in terms of the analysis of the evidence and had to do the work itself. And in my submission in this context, it will inevitably be possible in as skillful and experienced hands of those of Mr. Drabble to retrospectively pick holes in a tribunal's reasoning. There is simply too much evidence of too many different types floating around in this case to be, for all points, to be neatly and comprehensively tied up. But in a case as difficult and detailed and complex as this one, it will always be possible to find some fault in the reasoning. See Lord Hoffman in Piglovska. And those observations in my submission apply a fortiori in this context. So, my lords, my ladies, with those three submissions of general context having been made, could I turn to the detail of the reasoning and the evidence that was before the tribunal? And in terms of the structure of these submissions, can I take up the appellant's written case at paragraph 70, MS823, which is internal page 25 of the case, for a convenient summary of the specific criticisms or aspects in which Mr. Drabble says that the reasoning was inadequate. And as the court will have seen, four errors or inadequacies are identified at paragraph 70A at 70D. First of all, A, they failed to show how they reached the conclusion that there was a consensus among the medical experts that the appellant must have been unconscious when burned on his back. B, over the page, they failed to indicate the evidence on the basis of which the upper tribunal concluded that the medical evidence as a whole showed that Dr. Zapata-Bravo's opinion that the appellant could have remained unconscious whilst burnt on his back was implausible. C, they failed to address the evidence that the scars on the appellant's arm were different to those on his back in a way which lent support to his account and could not have been accounted for if he was anaesthetized. And C, they failed to attach D, forgive me, they failed to attach considerable weight to the fact that injuries which are SIBP are likely to be extremely rare. Now, I acknowledge, having heard Mr. Drabble develop the argument yesterday, that it's B and C I have to concentrate on primarily, and that D may be dealt with very briefly. But can I start, nonetheless, with the criticism at A, namely the tribunal's conclusion that there was in effect a consensus that the appellant must have been unconscious when the burns, at least on his back, were inflicted. Now, I start by making, I'm sure, the obvious point that it was always the appellant's case that he was unconscious when the burns on his back were inflicted. And so there was, as it were, no real dispute about this in terms of argument in front of the tribunal. He didn't say that he was being held so tightly that he was unable to move, and that explained the perfect delineation of the scars. He said he was unconscious, and so to that extent the point was uncontroversial. But could I turn first of all, please, to Dr. Zapata Bravo's evidence about this, which is at page MS 1374 in core volume 2. And before we turn to the evidence on this specific issue, could I just briefly remind the court of the account given by the appellant to Dr. Zapata Bravo as to the circumstances in which he came to be burned. At paragraph 5 on page 1374, he identifies that he had been in detention for 3 months, by the time the relevant incident came to take place, during which he had been repeatedly beaten, kept in poor conditions, etc. And then one day he was taken for interrogation to a room within the centre where he was detained. And then at paragraph 9, at a certain moment, when he was kneeling in front of the officer conducting the interrogation, and his arms were held from behind by a soldier who was firmly pressing them with his hands against his body, another person came from behind and firmly put his hands around his head. Immediately afterwards, he felt an intense surge of heat coming from behind on the right side of his head. He instinctively turned his head towards the heat as much as he was able to do so. He saw the glowing end of a rod, pain, screamed, fell forwards, and doesn't remember anything else, and gave an estimate, and no one's holding this against him, gave an estimate of being unconscious for 2 hours. Now, the court will note the distinction between that account and the account he gave Dr. O'Deely at paragraph H6 of her report at MS 1392 of being held by between 5 and 10 people. But I flagged that up merely in passing. He goes on to say that in paragraph 13, that after the burning, he was taken back to his cell in pain. He felt febrile for 2 to 3 days after the episode. The unhygienic and unsanitary conditions of his detention didn't change. He didn't receive any treatment for his injuries, local or general, and the burns healed in approximately 4 months. Now, Dr. Zapata Bravo, in his report, gave careful consideration to the question of the appearance of the scars and what they indicated about the appellant's level of consciousness at the time that they were inflicted. And what it comes down to in my submission is what he says at paragraphs 57 to 59 at page 1384. And these are paragraphs that the court has seen already and been referred to by Mr. Drabblin, so I won't take time by reading them out again. But the purpose of reminding the court of them in my respectful submission is that it's important also, when considering them, to take into account paragraphs 68 to 71 as well at page 1386. And could I, because I'm Strabble, forgive me, but I don't think we looked carefully at these paragraphs yesterday. Dr. Zapata Bravo says at paragraph 68, as discussed above, the appellant should have to stay nearly motionless during this lengthy operation. It would have been difficult for the individual to remain immobile without restraint, sedation, or anesthesia. being restrained by third parties would have required the participation of one or more operators in addition to the person in charge of the rod, and for reasons explained in the previous section, complete immobility would have been difficult to achieve. The use of sedation by alcohol or medication would not have produced the total analgesia required to eliminate all reaction to pain and thus generate these particular scars. And then could I just note paragraph 71 for the purposes of a submission I'm going to make shortly. The only way to achieve complete analgesia and immobility, other than the unlikely one of inducing the process of shock or coma that the appellant might have suffered on the day of the incident, was to use general anaesthesia. And I'll return, if I may, to that paragraph shortly. But the short point, my ladies, my lords, is that Dr. Zapata Bravo was clearly saying that in his professional judgment, the appellant must have been unconscious when the burns on his back were inflicted. Because otherwise, the total analgesia that would have been required to eliminate all reaction to pain could not have been achieved. And his oral evidence confirmed that view in terms which in my submission could not have been any clearer at page 3, supplementary MS, page 340. And the essential point being, I'm so sorry, my lord. The supplementary MS 340.
Thank you.
The essential point being explored by Mr. Duffy in further cross-examination, I think, was whether it might have been possible to achieve the perfectly symmetrical branding through some means of restraint through ropes or chains, in other words, being tightly tied up. And Dr. Zapata Bravo says, I doubt it, because no immobility would be able to stop the muscles to have what affects intense contractions that would follow the application of a high-temperature rod or other element. And the back in young people, young men, is full of muscles, etc. So what he's saying, unequivocally in my submission, is that no amount of restraint, doesn't matter how tightly you're tied up or chained up, not that that's his evidence, or held, is going to stop your muscles contracting and blurring the edges of the scars on the back. And that analysis of Dr. Zapata Bravo on that, my submission, crucial question, was not challenged or contradicted by anybody. As far as Dr. O'Deely is concerned, whilst we're in the same supplementary MS bundle at MS 321, she says in her oral evidence something very similar. At line 18,
Sorry, could you give me the page reference?
Sorry, my lady. It's supplementary MS 321.
321, thank you.
And the relevant passage starts at line 15, when in questioning, again by Judge Story, who took up the burden of most of the questioning in this case, he explores with her the concept of immobilization that she raised in her report. And you will have seen that in argument, certainly in written argument, my learned friend Mr. Drabble sought to distinguish unconsciousness from immobilization as if they were different concepts, and in my submission not convincingly, and in particular not convincingly because of what she says here. Can we take it from that, looking at the scars and the patterns, you are confident that he would have had to be immobilized? She says they're perfectly straight. We can infer that we're talking about the back here. They're perfectly straight, there's no blurring of the lines, and the temperature required to cause that kind of scarring, you or I would not physically be able to keep still without moving or flinching. And that flinching would have blurred or changed the appearance of the scars. They are perfectly symmetrical. And just looking at them, they look like they've been caused by the same item over and over again. And that evidence as to flinching, that you or I wouldn't be able to resist or stop flinching if a heated metal rod was applied to our back, is essentially consistent with the evidence of Dr. Zapata-Bravo, is that the muscles in the back would contract even if the subject was being heavily restrained. And for what it's worth, and just to complete the set, Dr. Arnold, who, as the court will have seen, was called not for the purposes of giving any opinion as to this appellant's scars, he hadn't even seen them by the time he got into the witness box, but rather for the purpose of answering the question raised by the first-tier tribunal, which was whether it was possible to differentiate between scars caused deliberately and scars caused by invitation. He essentially says, I'm not able to say. And the relevant pages in the transcript for these purposes are supplementary MS 380 and supplementary MS 383. And so, in short, and to conclude this analysis of the first criticism made by the appellants of the tribunal's reasoning, they were entitled to find that the appellant must have been unconscious when the scars to at least his back were caused. And they were also entitled to find that there was a broad consensus amongst the medical experts on that crucial issue. Much was made before the Court of Appeal about the accuracy of the language used by the tribunal in expressing themselves in terms of agreement between the experts. In my submission, they essentially did agree, but nothing turns on it. There was no dispute about it. Might be a more convenient way or more accurate way of putting it, but that's not a distinction with any difference. So, step one in the reasoning of the tribunal is solid in my submission. He must have been unconscious when the scars to his back were inflicted, and they were entitled to that conclusion. Now, the next step in the analysis, and picking up the next criticism made by my learned friend in his written case, is, are they entitled to reach the conclusion that it was medically implausible for him to have remained unconscious during repeated applications of the heated metal rod as he claimed? Again, to put it slightly differently, has Mr. Drabble demonstrated that that is a conclusion they were not entitled to reach? Now, before tackling that crucial issue head on, because in my submission it is the central question that goes to the heart of the validity of the tribunal's reasoning. Can I deal first with the issue of the different appearance of the scars on the arm and the back, to the extent that to see whether that bears in any material way on the answer to the critical question? And in my submission, perhaps unsurprisingly, it doesn't. And the first reason it doesn't is because the evidence that there was a material distinction in the appearance between the scars on the arm and on the back was flimsy, and doesn't seek to bear the weight that Mr. Drabble now seeks to place upon it. Of the three experts who examined the appellant, a physician, Dr. Lingham, a plastic surgeon, Dr. Adili, and a psychiatrist, albeit I of course accept with HBF training, Dr. Zapata Bravo. Dr. Zapata Bravo was the only one who identified a material difference in the appearance of the scars in comparing the arm and the back. Could I take you first, please, to what Professor Lingham says about it in his report in the second core volume at MS 1404. Just reminding the court very briefly, if I may, of 1402. You were shown yesterday by Mr. Drabble the analysis of the individual scars 1 to 6 that Professor Lingham undertook in the course of his report, and of course at 1408 you have the photographs for what they're worth in photocopy that he took. And what he says about the scars at the top of 1404 is that all these scars are similar in appearance, and therefore one would come to the conclusion that they are all caused at nearly the same time and by the same mechanism. Now, Mr. Drabble makes the entirely fair point, which I readily accept, that he does not go into detail, or at least the detail that we are about to see from Dr. Zapata Bravo, about the issue that we're now concerned with. But what he does say, and all he does say, is that the scars are similar in appearance and were caused at the same time and by the same mechanism. And he does not suggest that there is any material difference in the appearance of the scars on the arm, the appearance of the scars on the back. Nor does Dr. Adili. And her report, her evidence on this issue, is at MS 1393 in the same volume, please, at starting at paragraph 01.
Beg your pardon, could you please give me the page again?
Certainly, my lord. It's MS 1393.
Thank you very much.
Which is 511 in the second core volume. Now, I should qualify perhaps the submission I just made by observing that Dr. Adili does identify a difference between the scars on the arm and the back, but not in the way that Mr. Drabble says or now seeks to rely upon. What she says in paragraph 01 at the top of the page is that in the last 3 lines, alternatively, a heated rod which was starting to cool down would cause less tissue damage and scarring than a newly heated rod. This would explain why the scars on the arm are slightly wider and darker, as these were the first reported areas of burning. So she does identify a distinction, but not one based upon consciousness as opposed to unconsciousness, one based upon the extent to which the rod was heated. She then says...
I thought we weren't looking at consciousness. I thought we were looking at the marks.
My lord, the argument that my learned friend makes in criticising the tribunal's reasoning is that there was good evidence that the scars on the arm were different to the scars on the back, and that corroborated the appellant's account. Mm-hmm. And his criticism of the upper tribunal, as I understand it, is that their reasoning was inadequate because they don't grapple with this good evidence of corroboration, and therefore the reasoning is inadequate. And what I'm attempting to show, is that the good evidence of corroboration that he now seeks to identify of these different appearances is not as good as he's making out. and that in those circumstances the error he purports to identify is not as serious as he's attempting to suggest.
I was just picking you up on your reference to unconsciousness, which seemed to me to be not relevant to whether the clinicians noticed a difference. But anyway, proceed.
Thank you, my lord. I'll hope to do a better job of explaining the relevance of this when we come to Dr. Zapata Bravo in just a moment.
Thank you.
But the point I would simply invite the court to note for present purposes is that Dr. Adili does notice a difference between the arm and the back, but she attributes it not to consciousness, unconsciousness, as is now being relied upon, but to a different cause. She then says at 05, all 6 scars on his back and the 2 on his right arm are typical of being burned by a heated metal object, such as the bar described by the client. And all I do there, for what it's worth, is note that she does not identify any distinction between the burns on the arm and the back in terms of the mechanism or manner in which, circumstances in which they were caused. And then at 07...
Why does she say 6 scars on the back?
That, my lady, is a reference back to E3 at page 1392, where she identifies 6 scars on the back because she considers that the 3 lines down the appellant's back are each made up of 2 individual scars. There is a degree of difference between the experts about this. Professor Lingham, as you've seen, says that there were 6 scars. Dr. Zapata Bravo says that there were 7, and Dr. O'Deely says that there were 8. And and
you could make a case for 5.
You could, but the discrepancy is explained by how the extent to which you subdivide the ones on the back, and whether there is in effect you postulate a gap in the middle of the back.
Whether there's another one on the lower one, whether there's another scar on the lower back.
Yes.
Okay.
In fairness, perhaps, and I won't invite the court to get the photographs out now, but these experts were looking at the appellant at different times with gaps of up to a couple of years, I think. And in the first photographs that you were provided with yesterday, shortly after his arrival to the UK, at least the top scar across the back is clearly all one scar, as Professor Lingham identified it to be. But it may be that the appearance changed, certain parts of it faded, and so on. But I'm not sure I can do any better than that, my lady, than just to refer you to E3 as to why she's saying 6 on the back.
She refers to photo 2, which I assume is the one at 1396. I don't see that they're numbered.
Yes, my lord, I think that is right. And as I understand it, if one looks at 1396, she's identified a faint scar on the bottom left.
But slightly above the one on the bottom right.
It would appear so.
Yes, about a finger's width above.
Now, Dr. Zapata Bravo, for what it is worth, doesn't give that an L number.
No.
Or an S number, I'm sorry. But Dr. Adili, the plastic surgeon, has. Could I just finally, by reference to her report, go to 07, which is a paragraph that the court has seen before, albeit for a different purpose. She answers the essential question that all of the experts were posed in this case, namely, it's not clinically possible to differentiate between scarring caused with consent and scarring caused by torture. The scar would look the same in both scenarios. But then she says the distribution of the scars and the type of the scars would have required him to be immobilized or unconscious. Well, we've looked at her oral evidence as to what immobilized must mean in these circumstances. You can't even flinch. to deliver the burns. The client reports that he was immobilised and that he was unconscious for most of the time the burns took place. Even if he'd consented to the burning, the pain would have been such that he would have to have been immobilised or he would have moved. The burn scars are so similar with no blurring or smudging. Now, the point I make there is that we've seen her oral evidence saying that even flinching would change the appearance of the scars. We can see from the report that she was well aware of the claimant's account, the appellant's account, that he was unconscious, quotes, for most of the time the burns took place. But she provides no support at all for the difference in appearance of the scars now relied upon by Mr. Drabble. And on the contrary, she says that the scars, all of the scars by reasonable inference in my submission, are so similar with no blurring or smudging. And so the appellant gets no support in my submission for the argument now being run on appeal that there is an important and material distinction between the scars on the arm and the scars on the back that corroborated his account from the evidence of his own plastic surgeon.
It's interesting, though, that the upper tribunal, when they're referring to this point at 342 in their decision, paragraph 342, talking about date of when he said he was subject to the burning, and then they were all agreed as well that from the fact that the scarring on the appellant's back had precise edges and patterning, he would have needed to be unconscious. They don't say scarring full stop.
They don't, my lady. I accept that. And I also accept that it is possible to draw an inference from that language that perhaps they had in mind that there was some distinction in the appearance between the scarring between the arm and the back. I would have to accept that is an inference that can be drawn. Whether that is the correct inference, though, in my submission is not possible to say with any confidence. And that's, in my respectful submission, that is the danger that lurks in the over-textual analysis of tribunal decisions of this sort. I mean, it's possible that they may have had something along those lines in mind, but we don't know. What we can say, though, is that in terms of the evidence before them as to whether there was some importance to the difference in the scarring, which in some way went to supporting the appellant's case, there was evidence going in different directions. There was Professor Lingham saying, I don't see, for my part, that there's any material distinction between these scars. There's Dr. O'Deely saying, I don't, for my part, see that there's any material distinction between these scars, and certainly not saying, I think they corroborate his account, even though she was well aware of her Istanbul Protocol obligations, to which I'll return. Which just leaves Dr. Zapata Bravo. And I accept, of course, in the paragraphs that my learned friend took you to yesterday, to which I'll turn in just a moment, he does say that there is a material distinction in the appearance of the scars between the arm and the back.
I mean, the difficulty, Mr. Sheldon, is this. We must be very careful when we look at the photographs at 1396 and 1397 not to draw conclusions, amateurs as we are, of our own. But you might have thought that where Dr. O'Deely says the burn scars are so similar with no blurring or smudging, and attaches, am I right, the photographs at 1396 and 1397, there might have been cross-examination to the effect, you say that, Dr. O'Deely, can we just look at these two photographs, please? But of course, nobody said that to her, because Dr. O'Deely was the witness for the appellant. She wasn't going to be cross-examined by the appellant. It wasn't for Mr. Duffy, as it were, to deal with this, nor was it for the upper tribunal judges. So So nobody actually raised the obvious question one would have liked to have seen an answer to. What about these photographs?
Yes, my lord, I accept that. But there is an important distinction in my submission to be drawn between, on the one hand, identifying defects in the tribunal hearing process, of which there are several, and identifying reasons why the tribunal was not entitled to reach the conclusions it reached on the evidence that it was given.
Yes.
And in my submission, that's a distinction that must be kept clearly in mind. And one doesn't get to make the second species of points simply by identifying defects in the way in which this rather imperfect process was undertaken.
Very well.
And one comes back, and I'm sorry to keep doing this, but one comes back to the observations made in cases like AH Sudan about the particularly difficult context in which tribunals operate in this jurisdiction. And frankly, with respect to all of those involved, the tribunal in this case bent over backwards to try and get the evidence in ship-shape fashion for the determination of this important case. You will have seen from the appendix that there were no fewer, I think, than 6 interlocutory directions hearings where they set down directions and guidance and the sort of evidence they wanted to hear, the sort of reports they wanted to be commissioned. They undertook all the cross-examination or material cross-examination themselves. They identified that there was a gap in the evidence and that they needed an anaesthetist, and so suggested that the parties go off, and appellant in the end, go off and get Dr. Alam's report. They did their best with respect to them.
Yes.
And it comes back to the contextual submission I made earlier. When one's considering, well, were they entitled to reach the conclusions they reached? That's the context in which they're operating. So, my ladies, my lords, I was submitting that you don't get any support for the important distinction between arm and back corroborating the appellant's account from Professor Lingham or Dr. Adili. You do, of course, get it from Dr. Zapata-Bravo. And so could I take you, please, to Dr. Zapata-Bravo's report? And could I start at page 1380 at core volume 498? Now, Dr. Zapata-Bravo starts this section of his report at the previous page, 1379, I'm sorry, just above paragraph 35, with the subheading Interpretation of Scars. And he refers the reader to the scar diagrams in conjunction with the text below. He says, I found 7 scars. He had other marks not relevant, and so I don't address them. And then he says, importantly, this in my submission, at the top of page 1380, the following comments refer exclusively to the scars described above as S1, S7, i.e. all of them. And at paragraph 37, he says, all of these scars present similar characteristics in colour, shape, precise delimitation. The colour is the same in all of the scars, and it is characterised by hyperpigmentation, which is intense and long-lasting, suggesting that the initial burns were deep dermal burns. The long and narrow shape of each of the scars, with a very similar width in all of them, and the precise margins of these marks, suggest that the hot object causing the original burns was solid, for example, metal or glass, narrow or relatively long. And then he says, and this echoes Dr. Adili to some extent, only one scar, namely S6, situated at the top of the right deltoid area, is raised. Substantial amounts of scar tissue that can be palpated indicate that the original burn was a full thickness burn. All the other burns are non-palpable. And then paragraph 39, I think the court has looked at before. Now, at that point in his report, he doesn't identify any material distinction between the scars on the arm and the scars on the back. And picking up my Lord Wilson's point, that might have provided some scope for cross-examination of him when he gave his evidence, had this case been run differently. But importantly, I acknowledge, he does go on to provide a different or an additional view at paragraph 60, at page 1384. And in the passage that my learned friend Mr. Drabble quite understandably relies upon, at 60 and 61, he says that the scars in the right deltoid area, the S6 and S7, are different at this point to the scars on the back. He says that those scars, the branding is not perfect. S7 is not a parallelogram, and they're not in parallel to each other, as is the case with the scars on the back. This apparent inconsistency is explained if the appellant's report that he was conscious at the time is accepted. Now, that I accept is good, useful, helpful evidence for the claimant. However, at 66 and 67 on 1386, he returns to the appearance of the scars, and he says that the scars are diagnostic of burns produced by a heated rod and typical of an iron rod, as rods of other solid metal such as glass could have been used. Therefore, in order to produce these scars, the appellant needed to invite a third party to burn him with such an instrument, which required to be heated to a high temperature. Now, of course, in this context, he's considering the alternative SIBP option. Although I found 7 scars, it's probable that the original number of burns were 5. I'm picking up my lady's point from earlier. This means that the person invited to cause the burns did so on at least 5 occasions, twice to burn him in the deltoid area, 3 more times to burn him in the back. On each occasion, the rod should have been applied for several seconds. It should be assumed that a mechanism to heat and reheat the rod should have been available in the place during this operation, and then the relevant paragraphs in relation to immobility.
I should, he presumably means would.
I'm sure that must be right.
Yes.
So, whilst I acknowledge that Mr. Drabble derives some assistance from what is said at paragraphs 60 and 61, in other places in his report, both before and after that section, Dr. Zapata Bravo deals with the appearances of the scars without making any material distinction.
Can I just understand what he was saying in that report? Was he saying that the distribution of the shapes was different on the arm, or was he saying that the appearance of the scar within itself was different? It looks to me, reading that passage, in the middle one that you read us, that he was talking about the distribution of the shape that was made.
Yes, my lady, with respect, I think he's saying different things in different places.
Yes.
In the first passage I took you to, he was saying there's a difference between S6 and all the others because S6 has got deeper scarring, and yes, I think the rod was hotter. In 60 and 61, he's saying that there is a distinction because the branding effect is not perfect on 6 and 7, and therefore there must have been, or he thinks it is consistent with there being some movement. Movement by who is, of course, a moot point, either the inflictor or the subject.
But he doesn't seem to be talking about blurring at the edge of the scar so much as where it's placed on the skin.
Yes, my lady, I do take that point, because, of course, if you look at page 60, having said they're not perfect, he says that, for example, they're not in parallel to each other.
Yes.
And one of them is not a parallelogram. Now, the short and I'm afraid honest answer to my latest question is I'm not entirely sure what he meant. What Mr. Drabble, with respect, wants him to mean, and what he takes him to mean in order to found his criticism of the tribunal, is that difference in the scars on the arm is that the edges are blurry, showing that the person who was being burned was moving at the time that the rod was applied. That's what he wants, Dr. Zapata.
It doesn't need that, though, because it doesn't matter what it is about the scars that leads Dr. Bravo to that view. It is still his view that the cause may have been movement. But it would reconcile what Dr. Bravo was saying with what the other doctors were saying, if what he was commenting on there is distribution and not appearance of the individual scar.
Yes, my lady, I accept that, it would. But the purpose of traversing this evidence again from all three experts is to make the straightforward submission that the evidential picture concerning the appearance of the scars, and crucially, whether there was a material distinction which bore upon the credibility of the appellant's torture story, was at best mixed. Even in the report of the one expert who did appear to draw a distinction that might assist in corroborating, as it's been termed, the torture story, even in that expert's report, precisely what he's saying is not clear, and he's saying different things in different places. And so, when it comes to assessing whether the absence of express analysis of the potential difference in the scarring on the arms and the back amounts to an error of law in the upper tribunal's determination, I submit that the equivocal, contradictory, unclear nature of the evidence on this point means that the answer must be no.
You've got a lot of ground to cover in 50 minutes, so I must not ask you too many questions. Without going to it, you will agree, will you not, that in his oral evidence, Dr. Zapato Bravo reaffirmed that there was a difference between the scars on the arm and the scars on the back.
I do agree with that, my lord.
Very well.
I've already made the point, having dealt with what in my submission was the unclear, equivocal, murky nature of the evidence on this issue, that nothing was made of it by the appellant's representatives in their submissions. Now, you have not been provided with the transcript of the submissions, but you do have the tribunal's record of it, and nowhere does this appear as an argument. Also, and as in my submission correctly observed by Lord Justice Sales at paragraph 80 of the judgment, at MS 915, even if you, I'm sorry, even if you take as a starting point the conclusion that there is a relevant and material distinction between the appearance of the scars on the arm and the back, there are a number of possibilities as to why that difference may have arisen. Now, Lord Justice Sales identifies some of them in paragraph 80, but there were also potential explanations identified in the course of the evidence. And for these purposes, could I take you just to one reference in the supplementary MS bundle at supplementary MS 382, Now, at 382, Dr. Arnold is being questioned again by, I think, Judge Story, or it's not entirely clear. If you look back to 380, I'm afraid I'm struggling a little bit to understand precisely who's asking the questions. It might even be Mr. Duffy, it might be Miss Beati, they appear at different places. But in any event, he's shown Dr. Zapata Bravo's report, and at 382, line 20, he says, "I've been shown Dr. Zapata Bravo's report." This is in the context of the different appearance of the scars on the arm. He says that doesn't tell us whether, for example, either the subject moved or the person applying the rod moved, both of which he would appear to identify as being potential explanations for why the appearance might be different. And so even if Dr. Zapata Bravo is saying what Mr. Drabble says he's saying, that the scars on the arm are blurred because of movement, and that corroborates the appellant's story of being conscious when the first scar was inflicted, that's only one possible explanation. And Dr. Arnold identified at least one other one. There are, of course, a whole range of others. It's not helpful, I anticipate, for me to speculate, but in addition to the ones identified by Lord Justice Sales, one could envisage a situation in which an individual is inadequately anaesthetized on the first attempt to produce a scar through burning, such that the person doing it to him or for him tops up the anesthetic for the other burns.
Well, there's no evidential basis for that.
Well, no, there isn't, my lord, but this then comes back in terms of whether or not this is a defect in the tribunal's reasoning to the sort of argument that was had in MA Somalia that we looked at yesterday. It's not necessary for the tribunal, or indeed the Secretary of State before the tribunal, to come up with or prove an alternative possibility or hypothesis. It's enough to consider whether or not the appellant has discharged his burden of proof. Now this, all I'm saying, I think, is this crucially important bit of evidence, which Mr. Drabble says the tribunal failed to do adequate justice to, was not a crucially important bit of evidence at all. It's equivocal on the expert evidence, and even if you accept that there's a difference in the appearance of the scars, there are a whole host of possibilities as to why that might be so, many of which don't help the appellant. So, just before I come on to what I've identified as the crucial question on the question of whether he could have remained unconscious, could I just recap where I've got to, at least I hope I've got to. First of all, they were entitled to find that the appellant had to be unconscious when the rods were applied to at least his back. Secondly, they did not commit any material error of law in not addressing in detail the question of whether or not the difference in appearance of scars on the arm and the back made a significant difference to the appellant's credibility or assisted him materially in making out his account. Which brings me to the final question. And the essential argument that is run by Mr. Drabble is that the tribunal did not express adequate reasons for the conclusion that he was unlikely to have remained unconscious, or that it was clinically implausible for him to remain unconscious. And in particular, they didn't address the evidence to the effect that poor physical condition and illness can affect the duration of a loss of consciousness. The first and I suspect obvious point that I make in response to this is that this is a clear example in my submission of a complaint about a lack of weight given to a particular part of the evidence that the appellant now considers to be helpful, which is dressed up as a point of law. Second, the characterization of the evidence by the appellant to the effect that it was clearly established by the medical experts that the appellant could have remained unconscious throughout the exercise of being burned on his back is wrong. That's not what the evidence showed, and I'd like to take you, if I may, to one or two of the key references. First of all, in the tribunal's determination itself, please, at paragraph 343, which is at MS 1017.
Sorry, MS?
MS 1017.
1017.
At paragraph 343, the tribunal addressed what I've been identifying as the crucial question. They say that, 4 lines down, if it was clinically likely that someone could be burned once, then fall unconscious yet not wake up, even when there were more applications of a hot metal instrument, there was nothing to be concerned about. But if on the clinical evidence that scenario was unlikely, then the appellant's account was clearly problematic. This issue was addressed by Dr. Zapata-Bravo in his oral evidence. But given that his answer then was that he considered it unlikely that a person who had fainted would remain unconscious upon fresh infliction of pain, that was a matter that should have been apparent to him at the stage when he was examining the appellant and preparing his written report. So the impression, clear impression, that the tribunal got from Dr. Zapata-Bravo was that he considered it to be unlikely that the appellant could have remained unconscious. They also took from his evidence, see paragraph 342, further up the same page, that the exercise of burning the appellant's back was likely to have taken 10 minutes. And I'm going to come on to the transcript of his evidence in this regard in just a moment. So what they took from his evidence was that the process of the burning of the back would have taken about 10 minutes, and that he considered it unlikely in his professional judgment that an individual could have remained unconscious for that length of time. Now, as to whether or not they were entitled to take that from his evidence, could I ask you to turn up, please, the transcripts? And first of all, MS 330. Supplementary MS 330. Now, sorry, my lady, am I...
No, it's fine.
Okay, sorry. Supplementary MS 330, the court will recall that it was shown yesterday the answer that runs between line 13 and line 24 by Mr. Drabble, culminating in the observation of Dr. Zapata-Bravo to the effect that, so yes, I cannot say exactly how long, but I believe unconsciousness was a clear possible medical effect of a combination of factors in which one burn or 2 very severe burns caused the unconsciousness. And at that point in his evidence, he was taken to paragraph 71 of his report, which we looked at a little while ago, and I invited the court to note. And it was put to him, you say, line 29, the only way to achieve complete analgesia and immobility, other than the unlikely one of inducing the process of shock or coma that he might have suffered on the day of the incident, was to use general anesthesia. And Dr. Zapata Bravo says, that's right. And then over the page at 331, on what basis, yes, go on, did you have a reply, please? Yes, I do. And then there's some inaudible. An explanation, because again, it's an estimation of what could have happened. In order to be as unconscious as he claims to have been, and also utterly unconscious, not to react to severe pain, he would have to be in a sort of comatose state. And that can be induced by drugs, not drugs in the sense of hypnotics or tranquilizers or alcohol, etc. Now, just pausing for a moment to consider the effect of that aspect of the evidence. It is evidence in my submission which is capable of pulling in more than one direction. In the first answer on page 330, he appears to be saying, appears to at least be acknowledging the possibility that a combination of factors such as dehydration, fever, ill health, malnutrition, with the shock of pain, could cause a prolonged period of unconsciousness. But then he's taken to his report, which appears to say that a process of shock creating an effect equivalent to general analgesia is unlikely, and that in order to acquire the marks that he has acquired, it would have been necessary for the claimant, the appellant, to have been utterly unconscious and in a sort of comatose state. We then pick up this issue again at 334 briefly. And could I just invite the court to note in passing the answers between lines 6 and 7, the subsequent 6 scars, so by this he means 1 on the arm and 5 on the back, were caused when he was unconscious. That appears to be the case. But then 336. And again, the court will recall being shown this yesterday, but could I pick it up at line 23? By all means, please carry on. Yes, thank you. The point to state is that I don't think they can, but I think the shock which is, say that may have occurred in this case, was longer for him to be burnt 4 times. You'll recall in his report, he describes a lengthy process. That's clearly the background to this. The process, I try to imagine, would have required at least 10 minutes approximately, and no more than that is necessary for what happened. Yes, and then, as my Lord has noted, and I entirely accept, he says, but that is again speculative. Now, quite what he means by that, so in other words, I'm speculating it could be 8 minutes, it could be 11 minutes, it could be 12 minutes, or whether he's saying, I'm not saying it's a lengthy process at all, as I've said in my report, and that 10 minutes is a complete wild guess, or whether some variation of that is not clear. But he goes on in any event at page 337, just to complete the references before I make my submissions on it. At line 14, he's asked, I think again by Judge Dawson, so that I do understand, is it your view that shock alone, which induced unconsciousness, would not be enough for that unconsciousness to be sustained, for the subsequent pain to be applied, without waking the patient up? There would need to be something else. He says it's likely, in general, yeah. Again, it's not clear from the transcript alone whether the reference to shock alone is a reference back to paragraph 71 of his report, where he says that shock would be unlikely, or whether it's a reference back to the earlier answer that we looked at, where he says perhaps pain plus malnutrition, dehydration, poor health.
No, but that's then clarified in the next few lines, isn't it?
Well, are you at line 28, my lord?
Well, I'm stuck at
19.
Oh, I'm sorry. No, quite right. You state the sustained state of unconsciousness can be attributable to poor health and neglect.
yes.
Yes. And do I understand dehydration and poor nutrition? Yes, but it can also be attributed to, looking at your report, to a drug-induced state of unconsciousness. Another way of explaining this as he was, well, that state can be achieved by certain drugs, particularly anaesthetic drugs. And then the passage that we highlighted yesterday about the possibility that he might have been the subject of a blow to the head, but that wasn't his case. Now, my lords, I take the court through this evidence for the purpose of demonstrating, I hope, that a textual analysis of the transcript only takes one so far. And it only takes one as far as the sort of warnings that are given in cases such as FAGE, which is at Authorities tab 32, MS 522, at paragraph 114.5.
That's the island hopping passage.
That's my Lord Kitchen's island hopping passage.
Commenting on my first instance judgment.
Was he, my Lord? I'm afraid I didn't pick that up. But my Lord Kitchen also says some, if I may say so, helpful things about about transcripts.
Yeah.
And how far an appellate court's analysis of the transcripts might get you. And also Authorities tab 30, MS 436, at paragraph 108 per Lord Kerr, to similar effect. And in my submission, the task that the court is invited to engage in relation to this issue, by picking its way through Dr. Zapata Bravo's transcript, for the purposes of seeing whether or not the tribunal was entitled to extract from his evidence the conclusions, A, that it would have taken 10 minutes, and B, that he's unlikely to have remained unconscious for those 10 minutes. That exercise is a paradigm example of what those authorities warn against, because you simply do not get the sense or the import or the significance of the evidence and the way it was given from simply trawling through the transcript in this way. And appellate courts should, in my respectful submission, be cautious about engaging in this exercise. The tribunal said what they took from his evidence, and they were entitled to take it. But, and this is the crucial rider to that submission, but they recognised that this evidence was not ideal, which is why they gave permission, it would again appear from the judgment at their own instigation, why they gave permission for further evidence on the subject to be obtained from Dr. Alam, the consultant anaesthetist. They've taken it as far as they can with Dr. Zapata Bravo, and they say that the parties should have permission to obtain more specialised expert evidence on this question from an anaesthetist, and the reference for that is paragraphs 181 to 182 of the upper tribunal's determination at MS 982, which I anticipate I don't need to turn up for these purposes, if I may. Now, once again, the circumstances in which Dr. Alam came to be instructed were not ideal. And Lord Justice Sales explains that at paragraph 24 of the judgment at MS 896. She wasn't provided with much in the way of helpful information, or any helpful information about this particular appellant. She was asked a number of generic questions, and she did her best to answer them on the limited information she gave. The Court of Appeal asked for copies of her instructions, but it was told that they had been lost, and a witness statement was put into that effect. But the essential point she made was that in her experience as a consultant anaesthetist, it is possible and known for people to faint or lose consciousness on the application of an unpleasant or painful stimulus. But in her experience, they usually regain consciousness very quickly, and usually within a few seconds, once they're lying down. And the tribunal, doing its best, sought to analyse that evidence at paragraphs 345 and 346 at MS 1017. And they explain what they make of it. And what they make of it, which is that applying that evidence, of a general nature I accept, to the appellant's case, they think it is implausible that he would have remained unconscious for as long as was being postulated by his expert. And you'll see that they consider carefully whether he would have fallen to the ground or lay down after the initial infliction of a burn on his account, and they think that he would. And so they put together two aspects of the evidence, Dr. Zapata Bravo on one hand, and they explain what they took from him, Dr. Alam on the other, and they reach a conclusion in my submission which they were entitled to reach. It is, of course, entirely possible that they could have reached a different one, but that is not the question, and that is not the hurdle that my learned friend has to clear. Has to persuade this court that they were not entitled to reach the conclusion that on the totality of the evidence, it was clinically implausible for this appellant to be unconscious whilst he was burned repeatedly on the back with a metal rod heated on each application to the same temperature.
Implausible is a higher test, isn't it, than mere unlikelihood?
It is, my lord.
You quite rightly pointed to the upper tribunal's primary finding at, I think, their paragraph 343, MS 1017, as unlikely as being what they got from Dr. Zapata Bravo. And yet their conclusion is, as you say, is or has to be implausible. Can you help on how they get to that higher degree of unlikelihood? Is it just by adding Dr. Allen to Dr. Zapata Bravo?
Yes, my lord. I think the short answer to that question is yes. What they get from Dr. Zapata Bravo on his own is unlikelihood. See paragraph 343.
Yeah.
But they then add paragraphs 345 to 346, yeah. Dr. Alam.
So you say that's their route from unlikelihood to implausibility?
I do, my lord. And just before I leave the medical evidence, could I just remind the court, I'm sure unnecessarily, but there was another aspect, in fact there were two aspects of the medical evidence in this case, which also bore on their overall conclusion, which we haven't examined in any detail because they don't form part of the appellant's case. But they also took into account, first of all, the unlikelihood, plausibility. I want to be careful about the way I express it. The way they express it is that he was very lucky for this not to happen, namely that the appellant didn't get infected after these burns, despite the conditions he was kept in. And they also remark upon the fact that despite having been, on his account, beaten for 2 hours every 2 to 3 days for 14 months, he did not present to Professor Lingham, or his GP, shortly after arrival in the UK and within 3 weeks of escaping, with anything other than a sore knee and a sore back. Now, they feed that in as well, and it's important in my submission in assessing whether they reach conclusions they were entitled to reach on the evidence as a whole, not to lose sight of those important aspects of the evidence too. My lords, my ladies, I indicated that I think I need to say very little orally about the criticism of the upper tribunal in not adequately giving weight to the rarity of SIBP, because in my submission they quite clearly did, and I've set out in my written case all of the references to rarity that the tribunal made, and indeed it was accepted by Mr. Duffy in his submissions. We didn't make many submissions, as I've already said, but one of the ones he did make was that SIBP is acknowledged to be very rare. So there's simply nothing in that point. And could I just commend to the court the relevant paragraphs of my written case on that, which are at paragraph 77 to 81 at MS 865. And deal in the 20 minutes left, if necessary, with the question of the role of a medical expert, unless I can be of any further assistance on matters of medical evidence as assessed by the tribunal. My ladies, my lords, I am, of course, acutely conscious of where I am. And if there is some important issue of principle arising from the observations made by Lord Justice Sales in his judgment, then it's clearly important we don't waste the opportunity to have it considered by this court, and I'm conscious of that. However, I do submit that there really isn't any significant issue of substance either between the parties on these matters or raised in a general sense by what Lord Justice Sales had to say. First of all, though, before I turn to his judgment, can I just make the straightforward point that the discussion that I'm about to embark upon does not have any material bearing on the outcome of this appeal, either in this court or in the court below. The observations that we're going to look at made by Lord Justice Sales were made in his discussion of the medical evidence set out by way of background. They don't appear in any material part of his reasoning, and nobody is suggesting that his criticisms of Dr. Zapata-Bravo in any way affected the analysis of either the minority or the majority as to whether the tribunal was entitled to reach the conclusions it reached. And in particular, important to bear in mind, it is accepted by everybody, and indeed my learned friend Mr. Drabble made this point clearly yesterday, that as far as the tribunal is concerned, it directed itself impeccably on this question at paragraph 314, which is MS 1009. My ladies and my lords, you might recall we looked at this paragraph yesterday, and in particular the reference made by the tribunal to SA Somalia and the judgment of Sir Mark Potter. I believe it's my Lord Wilson said to my learned friend, well, that's fine, isn't it? Or I'm sure in a more sophisticated way than that. And my learned friend said, yes, it was. Now, if we had gone to the Court of Appeal with everybody simply saying, well, the tribunal directed itself impeccably on the role of the medical expert in these cases, well, the discussion could have ended there. It didn't end there because the intervener who had made submissions below sought to make submissions in the Court of Appeal, again quite properly, about the role of the expert in cases of this sort more widely. And it's in that context that this issue arose, not in the context of any criticism of the upper tribunal, who did its job perfectly well in this case. So this is a discussion that doesn't bear on the lawfulness of the decision of the upper tribunal. With that in mind, could I invite the court just to remind itself briefly of what it was that Lord Justice Sales actually said? And could I pick it up at paragraph 32 of the judgment at MS 899? At paragraph 32, he says, having just quoted the relevant paragraphs, that the Istanbul Protocol, provides a sensible form of categorization for medical experts assessing injuries. Medical experts in this case were aware of it. Dr. Alam didn't refer to it, but that wasn't her fault. There can't be anything objectionable about that in my submission. Then he expresses a note of caution about the way in which Dr. Zapata Bravo used the Istanbul Protocol categorization in his report. Paragraph 63, he said that the appellant's scars discussed in the report are diagnostic of burns produced by the application of solid rods, view for which he gave detailed reasons supported by the other experts. But he also said that as to the possibility that they were produced by the instrument described by the appellant and in the way depicted by him, I should say that my findings not only do not contradict his history, but they are highly consistent with it. Now, just pausing there for a moment, my ladies, my lords, it is with respect to Dr. Zapata Bravo not entirely clear what is being said there. If in using the phrase highly consistent, he is adopting the rubric of the Istanbul Protocol, then he is identifying his conclusion as falling within the third of the 5 categories that are listed above. Namely, highly consistent, the lesion could have been caused by the trauma described, and there are few other possible causes. A degree of certainty or correlation that is materially weaker than D, typical of, which is an appearance that is usually found with this type of trauma, but there are other possible causes. Now, I don't purport to know what Dr. Zapata Bravo was intending to say in this passage. But if, as my learned friend asserts, he was attempting to draw a conclusion compatible with the Istanbul Protocol, it's not clear from his report, or indeed anywhere else, what the other few possible causes of the appearance of the scars that he's identified might be. Now, I simply make that observation in passing because I'm going to submit in a minute that all that the debate between Lord Justice Sales and Lord Justice Elias comes down to is how you interpret what Dr. Zapata Bravo is saying. And what Dr. Zapata Bravo is saying in my submission is not terribly clear. At least if you try and squeeze it into the pigeonholes provided by the Istanbul Protocol. Dr. Zapata Bravo's evidence, as I understood it, was that there are only 2 possible ways in which this scarring could have been caused, either through torture as described or by SIBP. So what the few others are, I'm afraid, is not clear. In any event, having made his observations at 33 and 34, Lord Justice Sales ends up at paragraph 35. This is where this analysis ends up, by commending to medical experts the upper tribunal's practice direction as to the role of experts in proceedings of this sort to remain within the bounds of their expertise. And there can, in my respectful submission, be absolutely nothing objectionable about that. So the starting point of this brief digression in the judgment is the Istanbul Protocol is a very useful categorization tool. The end point is the practice direction accurately sets out the obligations on experts. And quite frankly, what happens in the middle doesn't matter very much in my submission.
Well, Mr. Sheldon, there are two sentences in these paragraphs which are particularly criticised. You might like to focus upon them. The first sentence is the last one in 33. Dr. Zapato Bravo seemed to use the protocol highly consistent classification, but inappropriately in relation to the appellant story, which is something different from the trauma to which that classification is expressly directed. And then the second sentence, again, in relation to which particular criticism is levelled, is the third sentence in 35. The protocol focuses appropriately, in my view, on the question of the likely immediate cause of a lesion or wound, which is a proper subject for expert medical evidence. So I don't think you can finesse it all on the basis, well, what was Dr. Zapato Bravo saying? These are propositions about the meaning of the protocol.
Absolutely, my lord. And perhaps I can attempt to shortcut this by reference, I hope not unhelpfully, to a practical example which sets out the Secretary of State's position on all of this, and then consider, having done that, whether there is really any difference between that and what Lord Justice Sales is saying. Because to some extent this argument has been undertaken thus far on a relatively theoretical and esoteric basis. The example I'd invite the court to consider is an individual who presents from a particular country with a number of round burn scars on their arm, which he says were the result of being tortured with a lighted cigarette 2 years ago in detention. A medical expert, considering that individual, can express an opinion as to whether or not these scars are highly consistent, typical, diagnostic of being burnt with a cigarette. That's obvious. The expert can also say, if it is within his expertise, these are full thickness burns, which have destroyed the entirety of the dermis. Therefore, the cigarette must have been held in place for more than 10 seconds, and that would be consistent with his account of it being held there deliberately, and not consistent with it being accidental. The expert could also say, I have aged these scars to more than a year old, which would be consistent with his account of having been tortured 2 years ago whilst in detention. He could also say, these scars have the appearance of wounds which became infected, and so they are consistent with his account of being held in unsanitary conditions after he was tortured. And he could even say, if properly qualified, I have seen lots of people who have come from this particular part of the world presenting with scars that look like this. And so to that extent, they are consistent with the account of torture in this particular country which is alleged. An expert can do all of that, because all of that is within the expert's field of expertise as a medical expert. What the expert cannot do is go one step beyond all of that and say, therefore, I think this individual is telling the truth about his history of past persecution in his country of origin, or I think this is a credible man. Now, as I anticipate it, my lords, my ladies, as I discern it, I don't identify there to be any great dispute about any of that between the parties, or any dispute about where the line needs to be drawn. The line needs to be drawn at the limit of the expert's expertise as a medical expert, and at the point at which he or she goes over that line and starts usurping the fact-finding obligations of the tribunal, which are to assess all of the evidence in the round, including evidence that the expert may not be aware of, in order to reach a finding on credibility. Now, in respectful submission, that's relatively clear. Now, what Lord Justice Elias says, if I could invite the court to look at that, at MS 923 and 924 in the judgment, is in my submission entirely correct. He starts at the bottom of 923 in paragraph 110 by referring to the relevant part of Dr. Zapata Bravo's report. His view was that these burns may have been inflicted when the appellant was conscious. He considered that the overall pattern of scarring was highly consistent with the account given by the appellant, namely that he was first burnt on the arms and then lost consciousness. Sales LJ submits that this was not a legitimate observation for an expert to make and that it was for the tribunal to make that determination. If the doctor was intending to express a view about the credibility of the appellant's account of events overall, I would agree. But I don't think he was intending to do that. He was commenting on the account of how the torture was inflicted. Scars were diagnostic of burning by a hot metal rod. Difference of appearance in the scars on the arms and back were highly consistent with the appellant's account of circumstances in which the scars had been inflicted, first on the arms and then on the back. Now, my ladies, my lords, I commend that entirely to the court. But all Lord Justice Elias there is saying is it really depends on how you read Dr. Zapata Bravo's conclusion. Lord Justice Sales has perhaps read it, it might be said somewhat harshly, narrowly, on the basis that he is trespassing into the fact-finding aspect, but I have to say I don't think he was. All I was doing by flagging up what in my submission was the ambiguity or lack of clarity in Dr. Zapata Bravo's analysis, particularly when framed within the context of the Istanbul Protocol, was simply to say that that was an issue on which legitimate views might differ. Lord Justice Sales read it one way. Lord Justice Elias says, well, if that is right, that's wrong. He's gone too far, but I don't think he was. And
Certainly you have no quarrel with the way Lord Justice Elias expressed himself in 110.
I don't, my lord. And it's no part of my role, and you'll see when you see the skeleton arguments and in direct answer to the question that was raised yesterday, the observations made by Lord Justice Sales in respect of Dr. Zapata Bravo's evidence were not the result of, did not have as their genesis any urgings made in submissions by me. I made no criticism of Dr. Zapata Bravo straying outside the boundaries of his expert evidence. That their genesis is simply the way Lord Justice Sales read it. Now, he may or may not be right about that. It's not entirely clear. But I don't, and from the discussion, I would not have anticipated there to be any disagreement from Lord Justice Sales with the example that I gave to the court this afternoon. Nor do I, with respect, see that there is any frank inconsistency with that analysis in the observations he made in passing in his judgment. But he doesn't need me to stick up for him, and it's not really part of my task to do so. But I hope that may at least assist in setting out where the Secretary of State stands on this question. And I think, my ladies, my lords, I'm out of time, and so unless I can be of any further assistance, I'll leave it there.
Just about, yes. Thank you very much indeed, Mr. Sheldon. I think no more questions.
Thank you very much.
Mr. Hill? Mr. Drabble.
My ladies, my lords, can I, first of all, just put in perspective from our stance the core medical issue, which can I characterise at this point as being whether Lord Justice Elias was correct in paragraphs 115 and 116 of his judgment, MS 925, to hold in the last part of paragraph 115 in particular, that there was, in his view, no proper basis for concluding that the possibility of remaining unconscious following his fainting was an unlikely explanation of the fact that he had not woken up. my view, the upper tribunal is here making a finding which it was not qualified to make. I do not accept that Dr. Allam's silence on the point justified this conclusion. My learned friend, in answer to a question from Lord Briggs, says that they accepted that the way in which the upper tribunal reached the view that my client's account, that he was burnt on his arm, fainted and was then burnt on the back, was clinically implausible, is a combination of the evidence of Dr. Zabato Bravo and Dr. Alam. My first task in reply is to submit that you can't amalgamate the two to produce a result of either unlikeliness or implausibility. Certainly no sound basis for the tribunal having reached that conclusion. So this involves looking again at material we've already seen, and I'll do that as quickly as I can, indeed I have to. If the court will go to Dr. Zabato Bravo's report, which is in Core Volume 2, starts at MS 1371, at the bits I want.
Sorry, MS?
It starts at 1371, MS 1371. The bits I want are the passage from MS 1379, paragraph 35 onwards. Because my learned friend's submission starts on the proposition that the evidence as to the difference between the scars on the back and the scars on the arm is, quotes, flimsy, I think is the words he uses, and then goes on to say that when you look at what Dr. Zabato Bravo said, it's unclear, it pulls in different directions. I simply do not accept either of those parts of it, but can I just repeat, I think, what I submitted in opening about the way in which one should read Dr. Zabato Bravo's report. If you look at CV 2497 MS 1379, the headings to this part of the report are important. Paragraphs 35 to 39 are under a heading Interpretation of Scars, and he describes them. Then there's a heading, Is it possible to diagnose with any precision with reference to the nature of the scarring when it occurred? We'd even be concerned with that. Then we get on to the issues that do matter. First of all, the heading is Possible Causes of the Scars, 1381. That passage is answered at paragraph 48. So by causes of the scars, he is asking what sort of object, what is the method by which my client's skin was burnt. And the answer is in paragraph 48, diagnostic or specific burns caused by a hot solid object. So he's not there looking at the characteristics of the scars for any other purpose than there to answer the question, possible causes of the scars, as his heading suggests. Then going on through the report, it deals with potential accidental causes in the heading above paragraph 50. And then the heading at MS 1383 above 53 is, could these burns have been produced with a 500 times 25 millimeter heated iron rod in the way reported by my client? The words "in the way reported" are important. That's the issue he's now addressing. Could these scars have been caused in the way my client reports? And of course, he had reported the same sequence of events at all stages of his recounts of the history. And the answer, for the various reasons that we've looked at in detail in paragraphs 57 through to 63, the answer is the end of paragraph 63, is they could have been caused in the way reported by my client. Indeed, that is the finding at in the last 3 or 4 lines of paragraph 63. So consistent with the account. So my submission, as it was in the Court of Appeal, is there's no tension between these different parts of the report. They're playing different functions in the way that the headings describe. So we then go on from that to the transcripts to see whether there's any issue about Dr. Zabate Bravo's view that the scars on the arms and the scars on the back were caused in the way that he has described in the report we've just been looking at, and were consistent with my client being unconscious at the time of the scars being imposed on the back. And if the court will now look at MS supplementary manuscript, memory stick number 330, we've looked at this, but he gives all clear oral evidence that the matters he refers to at 330 line 14, my client being physiologically weak for reasons I mentioned before, dehydration, lack of food, etc., poor health certainly, to have great pain, a great shock, a severe fever, to lose consciousness, and the length of it is difficult to guess. So that's the evidence. We were taken by Mr. Sheldon further on to 336. Where he says at the top of the page why that unconsciousness was so prolonged and so profound. I believe the explanation could be in that he explained to me that he'd been in a very poor physiological state and had been for several months on a very poor diet and very ill, would implicate he'd lost weight, etc. And he goes on to describe, after the 10-minute exchange round about line 25 and 26 of the transcript on 336, at the foot of the page, he's asked, my last question at this point relates to the impact of what happens to somebody when they become unconscious through shock as a result of pain. What can the effect be of the subsequent application of more pain? Then the answer is, if the shock had been purely a reaction of the pain, I think further pain could have woken him up. That is why I believe there's something else here. When people run an operation, they know the operation and anaesthetic and trauma and all that produce enormous physiological imbalance. You can plan the operation, but you can try to put the patient in terms of his best physiology. This man was not at his best when the shock by pain incurred, if you accept that he was burned in that way. And then we got the question and answer I went to in opening, straightforward acceptance at line 19. Sustained state of unconsciousness can be attributable to poor health and neglect. The answer is yes. So when we go to the tribunal decision, at paragraph 344, a central part of the tribunal's reasoning is predicated on the second part of paragraph 344, the proposition that if my client was able to remain unconscious despite several repeated inflictions of burn scarring, which clinically was an unlikely hypothesis. That is crucial to the reasoning that my client's account was clinically implausible. It's simply not sustained by anything Dr. Sabato Bravo has said. So the first of Mr. Sheldon's limbs on the road to implausibility is not sustained. There's no reason given for rejecting Dr. Sabato Bravo's account. They say you find it difficult to understand, and they don't say anything else. They then say that the account was confirmed by Dr. Allam, and my ladies and my lord will have seen the reference to Dr. Allam in 343, but also crucially in 345. What the tribunal draw from Dr. Allam is the last 4 lines of 345.
Three, four, five. Supplemental?
No, this is in the tribunal decision. I'm sorry.
Decision, yes.
It's my fault, I'm sure, but it's...
Just give us, without going to it, where in 343 the tribunal says subsequently confirmed by Dr. Allam. Just give us the reference which we must read in respect of that in the transcript, please, Mr. Travel.
It's not in the transcript, because that's part of the point. Yeah. There was simply a report. Yeah. A report written on the basis of no material at all about my client.
And so this business about 10 minutes that pops up at the end of Dr. Sabato Bravo, when I read this as meaning this was confirmed by Dr. Allam, but the 10 minutes certainly wasn't confirmed.
No, the 10 minutes certainly wasn't confirmed.
Very well.
And
sorry.
Nor, frankly, on a fair reading of what Dr. Allam said, was the proposition that it was clinically implausible that my client would have remained unconscious through the burning to the back.
Yes.
The point that it's clearest when you get into 345, the last 4 lines of 345. The tribunal record Dr. Allam, bearing in mind she only reproduced a report, and we're only talking about the answer to question 6, which we went to yesterday. Won't take you back to it now. But the tribunal comment, she refers also to other factors such as health or physical state that could affect the speed of recovery, but does not suggest such factors could have caused him to remain unconscious even when the hot metal rods were applied. But she wasn't dealing with a him. She didn't know she was dealing with a case of dealing with hot metal rods. Her evidence about fainting is, if your lordships and my ladies and my lords recall from yesterday, is in the context of administering epidurals, that sort of surgical intervention. And I can do no more in this stage in reply than invite the court to read the answer to question 6 by Dr. Allam and make the submission that it simply doesn't produce any basis for rejecting the evidence of Dr. Sabato Bravo, which I rather laboured as demonstrating that his view was that he would have gone into a profound state of unconsciousness, or could have gone into a profound state of unconsciousness.
You have easily to hand an MS number for that question 6 answer.
Yes,
don't worry if it's not easily to hand. I
can do it fairly rapidly, yep. Yep. Question 6 is MS 1225.
1235.
1225.
1235. Thank you.
I think we set it out in our printed case, actually, the answer to question 6. But so the building block, well, I've made the submission, the building block of Zabato Bravo's answers and coupled with a Lamb, in my submission, simply cannot produce an evidential basis for the crucial finding that it was clinically implausible that my client would wake up, ignoring other sophistications such as the use of the word unlikely. My client doesn't, of course, have to demonstrate positively that it was likely on the relevant burden of proof, but ignoring that, it just isn't an evidential basis. So that's the submission that I feel able to make in reply on the facts, and given the time constraints, I won't do any more than that. Can I then just deal with 2 or 3 points of law or authorities? My learned friend yesterday afternoon took court to MA Somalia, which is Authorities Bundle 2, tab 25. That's the report starts at MS 325. He says that MA Somalia is a case in which demonstrates that an asylum seeker can simply fail to make good his case in the circumstances which he says are analogous with the circumstances which are before the court. I don't accept that. MA Somalia, in my respectful submission, can be characterised as a no-evidence case. My client, as he was simply completely disbelieved. Your Lordship saw yesterday so that there was simply no evidence on which the tribunal could uphold his claim. At least that is the reasoning, contrary to my submissions, of the court. That is not the present case. The present case is one, as we've just seen, where the upper tribunal approaching my client's case state expressly that if the evidence on torture was convincing, the picture would change and would have to consider a real possibility that his account was correct. And one gets from that summary of their mental process the proposition, 1, they didn't discount my client's evidence totally. It was evidence. It had its problems, but they weren't saying he's lying to, he's a proven liar on whom no trust can be placed at all. But secondly, importantly, had the expert evidence been accepted by the tribunal, that would have provided, as the authorities we've got in our printed case demonstrate, independent corroboration of his account. So one would not be in the MA Somalia position at all. One would have had his own account corroborated by independent evidence. And the simplest way of demonstrating the independent role of medical evidence in this way is to ask the court just to look shortly at a case called JL, which is in the authorities bundle at tab 1. sorry, the Authorities Bundle 1 at tab 8.
Page, please.
Sorry, it's MS 95, and I'm just looking at the shortest way of taking you to.
Thank you.
I think it's sufficient for my present purposes just to point the court to the first sentence of paragraph 32. A statement that a medical report, even if it be of limited value, I'm not saying that my reports would have been of limited value, is evidence independent of the claimant's evidence. And then there's citation from Lord Justice Ricks in AM, which is also in the bundle. But the crucial point is we're not in MA territory because of the combination of evidence from my client coupled with the potential corroboration of that evidence by the experts. Turning next to the Istanbul Protocol, I don't think there's anything between myself and Mr. Sheldon now. We looked yesterday at the Istanbul Protocol. I took the court to paragraph 142. Let me just get the MS number. Tried it. 122, I'm sorry, that's my fault. But the MS number is 1307. 1307. Our submission is that reading the protocol as a whole, the purpose of the report prepared by the medical examiner is to provide expert opinion, as 122 says, on the degree to which medical findings correlate with the patient's allegation of abuse and to communicate effectively the physician's medical findings, so that you are looking for correlation. That will involve looking at the torture history, which is easily wide enough to include Dr. Zabato Bravo's acceptance or consideration of the acceptability of my client's account of the sequence of events which took place.
When Lord Justice Sales says, don't please you experts look primarily to the Istanbul Convention, look primarily to the upper tribunal practice direction, do we happen to have that in the bundles, Mr. Drabble?
I think the answer to that is yes.
At some stage, could we be given the reference to that? Or we can find it, no doubt, for ourselves.
Yes. Mr. Toll is finding it, and I'll,
thank you.
Before 1 o'clock, will ensure that you have the reference. And I mean, it's volume 5, tab 69.
Thank you.
Of the Authorities Bundle.
Page?
Well, that's another.
Tab 69, did you say? I can probably find it.
Yes, tab 69.
Thank you.
So that is at MS, supplementary MS 796.
Thank you.
Short submission in answer to my Lordship's question, effectively, is that the documents are playing two different functions. The practice direction is a general practice direction aimed at expert evidence. The Istanbul Protocol is a document setting out, as it were, the received wisdom is probably not quite the right word, but an appropriate approach which experts can adopt in providing useful records of medical evidence specifically in torture cases. And can we just make it plain that we, for our part, adopt what Lord Wilson said yesterday about the meaning of trauma, and in particular the reliance on paragraph 172 of the protocol.
172.
172 at MS 1315. The concept of trauma isn't limited to the physical application of the rod in my client's case, but is wide enough to encompass the whole of the torture history. Then finally, the submissions made on the basis of A.H. Somalia, H. Sudan, I'm sorry, about the role of the expert tribunal. Can I just, court will know about this, just refer the court to Lord Justice Carnworth in AA Uganda, volume, Authorities Volume 2, tab 23, passage is paragraphs 42 to 46 at MS 309.
Sorry.
309.
309.
Yeah. And I won't read it, but Lord Justice Carnworth, in common with Lord Justice Buxton, is expressing a view about the potential limitations to the language actually used in A.H. Sudan. And your Lord, ladies and my Lord, will see what is said in particular in paragraph 43. I could make much longer submissions on the Cook doctrine. I'm not in a position to do that. My submission is simple. It is that, of course, one as the higher court, exercises restraint in looking at the reasoning, both on fact and law, of a tribunal who can be taken to know what it's doing in normal circumstances. But that's an observation that's true in very, very many appeal cases. It's true in a personal injury case. You'll have an expert personal injury judge. It's true in patent law. You'll have an expert patent. The role of the appellate courts is to supervise, and they will do so on a common sense basis, recognising the expertise that the tribunal is likely to bring to it. That's no further than that. On AA Uganda, I should point out that Lord Justice Lloyd, page 312, paragraph 58, MS 312, paragraph 58, expressly left open the need for any gloss on the reasoning of A.H. Sudan. And finally, Lord Justice Calmers draws attention in paragraph 46, MS 310, to dicta of Lord Justice Sedley, set out in the quote, which are targeted precisely at asylum cases. And unsurprisingly, I adopt that approach too.
But as I understand it, those remarks were addressed to the comment that I made that appellate courts should approach questions of law on the basis that the specialist tribunal might very well know more about it than they did.
Yeah, I mean, there are two things.
Which I still believe to be the correct approach.
Yes, I don't have any.
But that's not in this case.
Well, that's not this case. No,
There
there are two different things that are happening. One is a warning which I understand full well to the courts dealing with, for example, social security, as the classic Cook doctrine. Don't assume that the specialist tribunal has simply got the law wrong. It probably knows what it's doing.
You've ended your submissions on a rather provocative note.
It wasn't really intended. I got diverted into the Parte Bravo before I came out with this. But anyway, that's my stance. As I say, there were two different things going on. I fully accept that. One is a warning about the don't assume the specialist tribunal doesn't know what it's doing in terms of the law. It probably does. And secondly, the deference that any appellate court will feel towards a fact-finding exercise. And we're in the second here. But, ladies, my lord, unless there's anything else on which I can further help, those are my submissions.
I think not. Thank you, Mr. Drabble. Thank you to all concerned. We all know that asylum cases, and particularly those involving torture of this alleged sort, do deserve the most anxious scrutiny from the courts. We've been giving it anxious scrutiny over the last day and a half, and we shall continue so to do until we've worked out what the answer may be. Thank you. Now I shall.